All right, good afternoon, everyone. It's 2 o'clock, and as Chair of the Albemarle County Board of Zoning Appeals, I'd like to call the meeting for March 12th, 2024 to order. Our first order of business is to establish a quorum, and I've been asked to do that a little bit differently than we've done it in the past. So what I'd like to do is just move from my left to the right, and I would ask you to say your name and then followed by the word present.
Ronald Rosenberg, present.
John Shepherd, present. Kurt Burkhardt, present.
Marcia Joseph, present.
Bo Carrington, present. And we also have Jim Bowling here. We have Deputy County Attorney Andy Herrick. We have Bart Svoboda and Francis McCall from the Zoning Administrator Office. And Miss Marcia Alley. I think that's it. So I'll move right into the public hearings. We have one on the agenda today, AP 2023-4, Challenger Way setback determination. And the way this will work is we're going to give the staff county attorney team 15 minutes to present their case, and then we will give the appellant and their team another 15 minutes after that. So without further ado, I would invite Mr. Herrick or Mr. McCall to kick us off.
Thank you, Chair Carrington, Francis McCall, Deputy Zoning Administrator. My presentation here should be fairly brief as laid out staff's the case for the staff's analysis of this in the staff report. And once I've finished, take questions or further discussions. So just to give you some context here, the property that we are discussing this afternoon is tax map 6101C1. It's a total of 3.51 acres. It's 442 Westfield Road, and it fronts obviously there on Westfield Road. The parcel is zone C1. As you can see here, I put a little, I've identified on this particular slide, the particular setbacks that are in question, and I've noted them here along the property line. So if you want to come back to slide number 3 for any discussion, slide 3 or 4, you'll see here in just a second that has the aerial photography of the particular site that has those lines on them. So if you want to come back to those, just let me know. I'll go back to those particular slides. So the purpose here of this meeting is to determine whether the zoning administrator's decision was correct and whether the zoning ordinance was applied correctly. This appeal does not consider whether the proposed use is appropriate, whether it is in the public interest, or whether the zoning regulation is invalid or needs to be amended. Here's the slight history of the property, or not slight history, but just the history of the property that was identified in the staff report. I'm not going to go over these particular dates, but these are outlined in the staff report. Again, if you want to come back to any of these slides, just note the slide numbers, and I'll be able to go back to those.
Francis, can I interrupt you just for a second?
Yes.
The first says it approved ZMA to rezone the parcel to neighborhood model. What was the parcel zoned prior to this?
I believe it was commercial.
Okay, thanks.
So the setbacks, the grounds here for the decision that was made are outlined in the code sections 18-21.7 and 18-4.20A. Those sections are outlined in the staff report as well, the specific language. Staff's response to the appeal, again, is in the report in a little more detail, but we do not agree with the appellant's claim, which is in attachment D. So because of that, zoning administrator's determination, LOD 2023-10 was correct. The Board of Zoning Appeals should affirm the determination. I have some motions. The particular one outlined right now is to affirm the determination, and if there are other decisions, we can present those motions as well, at least the starter language for those motions. So that's that first motion. I am available for questions, and as is our Deputy County Attorney, Mr. Herrick, for any further analysis here that he might want to present or have questions and answer any questions you all have. Excuse me.
So, Mr. Chair, members of the board, Andy Herrick, I'm the Deputy County Attorney here on behalf of the County Zoning Administrator. I just wanted to focus, reemphasize a couple of the points that Mr. McCall raised in his presentation. If you go back to slide 5, the basic purpose of the hearing today is not to determine the perceived fairness of the ordinance, whether the ordinance needs to be amended or not. It's simply, given the ordinance that the county has, did the zoning administrator make the correct determination? And specifically, we're looking at County Code Section 18-4.20A, which talks about what the setbacks are if a neighboring property is zoned residential, not whether it's used for residential purposes, not where the structures on that neighboring property are located, but whether the property is zoned residential. And given the fact that we've got a neighboring property that is zoned neighborhood model district, the challenge for the zoning administrator is to determine whether or not this category of neighborhood model district fits within what the zoning ordinance would consider zoned residential. That's the challenge for the zoning administrator, and that's the challenge that you all have been asked to decide today as well, whether a property that's zoned neighborhood model district constitutes being zoned residential. Again, it's not about perceived fairness. It's not about the structure of what the location of the structures. It's not about actual use. It's about the zoning of the property. And I would suggest to you that given the fact that this neighboring property is zoned neighborhood model district, that based on past practice and the way that the zoning ordinance has been applied previously, that in fact that type of zoning does satisfy residential zoning for purposes of the setback. On some related points, as the staff report calls out, the existing structures on that neighboring property, the appellant's property, are not illegal at this point. They are legally non-conforming. They can continue in their current state as legally non-conforming uses. And if the applicant wished to construct new properties or new structures within that 50-foot buffer, they could seek a special exception from the Board of Supervisors. I think that the practice that Mr. McCall was referring to in the staff memo is that there's actually been a scenario where this has arisen in the past, where an applicant has wanted to construct additional structure, where an applicant has wished to construct additional structures within that buffer, and staff has recommended and the Board of Supervisors has approved a special exception to allow those structures to be sited within this 50-foot buffer. So I think that the effect of that 50-foot buffer is not draconian. Again, there's the right to continue the existing building as a non-conforming structure. There's the ability to come before the Board of Supervisors for special exception. That has not yet been sought in this case, and it would be something again that staff would look into and make a recommendation one way or another to the Board of Supervisors. That's about all the prepared remarks I have to say. I'm happy to answer any questions that you have. Mr. McCall and I are, and then obviously we'll have some rebuttal time in response to any arguments that the appellants might make. So happy to answer.
One of the other options that was discussed was that the zoning could also change to that property as far as to a neighborhood model or some other district where it's no longer incompatible with the two zoning districts.
Are you saying that the property in question that we're looking at now could change its zoning? Is that what you're saying?
That's correct. If they wanted to, they could pursue that option to rezone their property and then no longer be subject to those particular setbacks.
How much does it cost to submit a rezoning application?
I believe it's in the range of $2,500 to $3,000, somewhere in there.
And what's the timeline on that? And could the appellant ask for an expedited process on that?
The timeline generally for any zoning map amendment is 6 to 9 months, or I think 9 to 12 months is approximately what that is. Expediting it, I don't think that option is in the ordinance. There's a standard timeline of staff review, planning commission action for recommendation, and then board of supervisors final action on their a proposal.
Thank you.
And how much does it cost for a special exception and how long does that take?
I believe that is in the range of $500. It's 500, 600, somewhere in there. I don't have the file. I can look real quick, but it's in that general, and that's 90 days.
Miss Alley, just for clarity, I want to make sure that Mr. Herrick's not still on the clock and that I will formally open it up for questions just now.
Mr. Chairman, a couple questions that I have, reading the report, which was an excellent report. Is the NMD zone defined in the ordinance?
So yes, it is. It's a zoning district. It's in County Code Section 18-20A. And at the outset of that section is a statement of the intent or the purpose of that district. I'm not sure whether the word residential is used, but I know that Mr. McCall has looked into that intent section of 18-20A.
Okay, and that definition, maybe I've missed it when I read. Could you just refresh my recollection, if it was in the record, how it is defined?
Would you like me? Yeah,
Yeah.
that's fine. It's defined as a planned development district with traditional neighborhood development and which established in the county's neighborhood model, which is part of their comprehensive plan. So if they were to rezone something, they're utilizing that model to basically evaluate those what they're asking to do as far as the mixture that they might have in there, which does include actually requires a mixture of uses, residential and commercial, in that as far as the uses of that
Okay,
Is it
district.
possible to put that definition up on the screen?
Maybe.
So there's not so much a definition, there's a statement of purpose and intent. And as Mr. McCall points out in 18-20AB, there's actually a requirement that each district must have two different general use classifications, both including residential being one of them.
right.
Right.
I've just one more follow-up question. So, in the report, you say, and Mr. Herrick said, that by consistent and longstanding practice, the NMD zoning district is considered residential for consideration of commercial setbacks, like our case here. Can you give us some idea what the history of that consistent and long-standing interpretation has been?
And I would defer to Mr. Svoboda and Mr. McCall are more familiar
Either
with
one,
specific applications that have come in the
Sure.
past.
Bart Svoboda, zoning administrator, Albemarle County. We've had a number of these rezonings, so typical with any type of rezoning, whichever district that the board approves that zoning map amendment to, it affects the adjacent properties one way or the other, the adjacent districts, right? So typically we see where a residential piece or agricultural piece is rezoned to commercial. And then there's effects as far as light, noise, parking hours of operations, things like that. This is particularly a kind of a different case that we don't hear much about, but it happens a lot. If you look at our other neighborhood developments, we have some in Crozet, even straight zone developments like Forest Lakes, where I rezone something from residential, from either commercial or ag to residential. Those new setbacks are now imposed on whatever the district is that already exists. So if we think about 84 Lumber as an example, on the corner of Profit and 29, that's a commercially zoned piece where that has an NMD next to it. And so when the NMD was adopted, it affects those existing commercial lots. And so there's some, as we go through that in different rezonings, that's kind of something to keep in mind. So with the neighborhood model, this is a neighborhood is the term. And so it's majority of neighborhood models are residential. I think in this particular case, in,
Two things.
yes,
Can you scroll to the bottom of, yeah, because I could, yeah, okay. And these are examples of characteristics of this NMD, those listed indented. Mixture of use, redevelopment. I'm just looking for something that explicitly says residential in the definition.
Excuse me, Mr. Rosenberg, could you speak into your mic?
Oh, yes.
Thank you.
I'm looking at what you're seeing now, and I'm looking at that indented list of characteristics of the NMD. And a mixture of housing types and affordability would suggest residential. So I see that, but the way this is written, it says, so let me just be clear. By consistent and longstanding practice, so have there been other situations analogous to this one where the person is affected by the 50-foot setback? But the planning staff says, but it affects a residential use, which is, or residential zoning, I guess is what you're characterizing this. So you can say, yeah, we have precedent for interpreting it this way.
yeah, one that comes to mind that's the most recent, and it was a couple of years back, is the old Condile plant. There's a picnic shelter out back that needed a special exception for the 50-foot setback. They're adjacent to Stonefields. And that particular area is actually closer to the Costco and that part of the NMD than it is the residential, but we applied the 50-foot setback there. The Condile owners, I can't remember the name of the building, but those property owners came in, got a special exception from the Board of Supervisors to reduce that setback.
So
to have that
can I
there.
clarify, Bart, just after looking at that again, that actual special exception, there was the disturbance in the buffer that they got, but it's more or less essentially an action, something that is required by that district that the board is permitted to reduce that requirement and allow them to do that. So by them granting that particular exception, they essentially allowed them to go also closer than the district allowed as far as the 50-foot allowance.
But these property owners followed the special exception method for obtaining permission to do what they will.
Yes, sir.
And to your point, it doesn't explicitly say that here. And that as far as it being just solely a residential district. With that ambiguity in there, that is what our particular jobs are as far as the zoning administrator is to make that interpretation. And that interpretation had been made in the past with, I don't know all of the conversations that have had or if anybody moved forward with those, but I'm fairly certain that there were other conversations with other properties. There aren't very many that we have that actually are abutting some commercial district that hasn't, say, already been rezoned itself, whatever it might be. But so being that they're few and far between, even though that says longstanding, that may have been a misuse of that particular word, but it still is something that we are doing every day as far as making those kinds of interpretations.
So just to clarify for myself on this, I think I understand what you're saying, but so basically you're saying that there is no exception to any neighborhood model to calling it a residential district. So no, it's not that, it doesn't seem to be determined case by case, it's across the board. That has been the longstanding practice. I wonder if that's your understanding of it, or if I'm exaggerating there. And has there ever been a determination that clearly gets into all of this stuff that we're talking about now? But you know, there's a lot that I could, continue here with the distribution of commercial uses within the neighborhood model. And if there's actually like a residential use within the neighborhood model against a commercial use outside versus commercial uses on that portion of the neighborhood model, we can get way into that. But with that being the context, is it just across the board, neighborhood model districts are interpreted to be residential for the purposes of setbacks?
I'm not sure that there's an official letter of determination on that subject previously, so there's not a reliance on a prior letter of determination. And this letter of determination is based on this particular site. So the issue before the zoning administrator and then the issue before you all is the application of that determination to this parcel, to the Challenger Way parcel specifically.
I understand that we're confined to that.
Right.
But in my mind, it's irrelevant. I'm going to connect the dots later. I think it's a relevant question.
I have one question, and it's maybe dovetails with Mr. Shepherd's. The determination says with previous, this is about halfway down the front page of the determination, which is attachment C. It says with previous decisions on setbacks from properties zoned NMD, it has been determined that the NMD is a residential district for setbacks noted in section 4.20A of the zoning ordinance. And my question is whether or not, when it says it has been determined that the NMD, does that mean this NMD, the Premier Circle NMD, or does it mean NMDs in general? Because each NMD is a planned development district, which is governed by its own code of development. And so I want to know if this code of development is what was being investigated, or if it's the neighborhood model districts in its entirety across the county.
So Mr. McCall can correct me if I'm wrong, but again, the way that sentence reads, from previous decisions on setbacks from properties zoned NMD, I would assume that that's regarding neighborhood model districts in general, because to my knowledge, this would be the first time that it had arisen in the context of the Premier Circle property.
Correct.
And so it would follow then that all NMDs are considered residential. Is that appropriate?
That's what's been determined in the past, and that was applied to this particular property.
And to apply 4.20, where it talks about residential or whatever the remaining or rural area or Monticello, those three zone districts, that's what we would consider.
And sorry to put a point on it, but the code of development then is not relevant in your staff analysis of whether it's residential or not residential?
That hasn't been part of the past analysis. I would say that in this case, if you look at the code of development on this particular property, block 2 of the code of development on this property is what abuts the Challenger Way property. And that block 2 on the code of development in this particular case, there it is on the screen in blue. And you'll note that the Challenger Way property, the appellant's property in this case, is the very top of the screen. It's the one that, and the hand is over it right now, that's the property. And you can see that if staff had performed the code specific analysis of this property, it would have supported the residential block 2, the property abutting the Challenger Way property as being residential.
Excuse me, but I think that the rest of the code of development designates that block 2, you're able to do all sorts of commercial activities in there too. It's not strictly residential.
There's a limited mixed use allowance there, but one has to look at the preponderance of the uses.
I agree with you, but we don't know what the preponderance of uses could be in the future. I mean,
Mhm.
from what I understand about the neighborhood model, it's supposed to be flexible
Mhm.
and allow people to do, to change organically instead of going through, the rezoning process.
But the only
So-
way, I'm sorry.
No, that's okay.
The only way to have those limited mixed uses in that block two is for that block two to be developed residentially. In other words, the allowances, I understand the code of development, maybe someone can correct me if I'm mistaken, but that the whatever allowance for commercial use is allowed in block two, it's only with the residential having occurred as well.
I can agree with that, but it gives you an opportunity to have a commercial activity or use, which we're not supposed to talk about, I guess, that would be directly adjacent to this particular parcel. So that could happen in the future because it's allowed by right.
Well, I would say that 1% commercial and 99% residential doesn't make a property commercial. It makes it mixed use at best and predominantly residential.
On that point, I know that, within the report was mentioned, well, at least from the appellant standpoint, there's talk about this being, transient lodging, homeless shelter, a possible use for that part that has been contemplated. And I look
Excuse
at
me,
the
Mr. Shepherd,
definition,
if you could speak into your microphone.
and I look at the definition of transient lodging. And I wonder if that's actually residential development. If we're talking about transient lodging, I think that's get into a few things. It's various things that fall under the umbrella of transient lodging are all taxed with the transient occupant
That-
tax.
I don't believe that that's actually what the use is. It may be short term, but it is not considered transient lodging in that same sense of the definition with taxes and things like that. So I'm not aware that that's what the purpose of this. They are going to be, there may be further slides that show their proposed development, but nothing has actually come to us yet as far as how they actually are going to use it. But I don't know if it's going to be short term or if it will be longer term for those individuals.
I understand that, and I know I'm on the edge of what is like within the confines of this discussion, but if an idea, if an identified use of this is transient lodging, which is what the special exception was for. Remember, there's a rezoning and a special exception that was mentioned, and that is in the Code of Development. And if you try to it's hard for me to understand what transient lodging is as a use. It's not a by right or special permit use in the ordinance, as far as I can tell. But I think it's including things that are clearly commercial. So to me, there's a commercial element to what's happening in this, potentially in this section 2 of the rezoning. And I think actually where it's not exactly in front of us, I think it is it has been well established that at least for the time being, that's what's being contemplated for this parcel.
So, I mean, I appreciate the thoughts as to the prospective uses that might be occurring on the Premier Circle property. But again, focusing back on the setbacks are whether it's zoned residential, not what the potential uses are. It's how is it zoned? And again, we would say that it's zoned residential. Again, there's the possibility of limited mixed use, but the zoning is predominantly residential, especially on block 2.
Well, if we're not going to say the zoning is neighborhood model, I think we have, if we're trying to bring the residential characteristics into play, then we have to talk about the uses, I think. Otherwise, you just say it's zoned neighborhood model. And that's just my thought pattern. I'm getting ahead of myself.
Yeah, it feels a little bit unwieldy to, the staff report, I think is is correct when it says, rather than use, the proper focus is on zoning. And I think that's what I hear you saying. And yet I also am struggling to wrap my arms around whether or not this code of development, which lists uses, is considered in the determination. And I'm not clear on that yet, but we have plenty ahead to get
Right,
clear on.
and I would say if a code of development is considered, this particular code of development, again, supports staff's determination as well, that the portion that's abutting the Challenger Way property is in fact residential.
And so would the county's position have the board disregard the code of development for Premier Circle or analyze it?
I mean, if the board feels that it's necessary to take a look at the code of development on a property specific basis, I mean, we wouldn't object to that. We would say that this particular code supports staff's determination.
I think that's part of your problem and issue before you today.
Okay, thank you.
All right, thank you.
So there's a couple of notes just to bring your attention to those charts that talk about the transient lodging. So table B talks about that it's multifamily. It's in the proffers, and I believe it is page 14. So it talks about multifamily or transient lodging. When this rezoning went through, transient lodging had to do with a strict definition about how long somebody stayed there. Right. So as a permanent shelter with folks staying anywhere from 0 to maybe a year, in order to be able to accommodate services for folks that were there less than 30 days, that's where the transient lodging definition comes into play in this particular rezoning. Also, if you look at, I believe it's note 2, it talks about the non-residential square footage of the project has to be in block 1, right? And note number 3, the maximum gross density not to exceed 140 dwelling units. However, the total density may be allowed in block 2 only. So that's 140 units in block 2. So that's where the part, if you're looking at the code of development to talk about what's residential and what's not, that's where that comes from. There's restrictions on this that don't allow commercial to be the majority of the use in that particular block.
You have 140 residential units allowed, but what's the minimum that's required for block 2?
40, right?
Yeah.
80.
80 in the chart, 80.
Okay.
Got that. Okay.
Thank you.
I guess this can conclude our questions portion. Thank you for that. And now I would like to open it up for 15 minutes of comment by the appellant and or legal counsel for the appellant.
Thank you. Good afternoon, members of the board. I appreciate your time this afternoon. With me here is Sue Steinmart, who's one of the owners of the property. And I am counsel for the owner, and we'll give you a brief presentation and we can both answer any questions that you might have. We don't disagree with some of what was said in the context of, this isn't about a specific use. It is about the zoning, those types of things. We 100% agree with that. And I'm happy to get into the weeds of some of the things that you all have been talking about so far, but I think this is actually a lot simpler than it seems like it might be.
Could you identify yourself, please?
Yeah, I'm sorry. My name is Pete Karamanis.
Thank you.
I should have said that at the outset, and I apologize. And I signed the sheet and I thought everyone would know who I was. That's my fault. The first thing I want to point out is that, and this had been mentioned, but the neighborhood model district is a planned development district. That's how it is categorized in the zoning ordinance. It is not categorized as residential. It is not categorized as commercial. It is categorized as a planned development district, along with several other districts that have their own names, PUD, PRD, the Monticello district, all planned development districts. That's the category that we're operating under here. The section of the ordinance that staff has relied upon talks about, if a property is adjacent to residential, rural areas, or the Monticello Historic Districts. So Monticello Historic District is one of these planned development districts. It is specifically referenced. So that's, they pulled that one district out to say this planned development district is subject to what we're talking about here. The other things mentioned are residential, which there are districts called residential. I mean, that's literally the name of them, the residential districts. And rural areas, which again is the name of a district. So what you've got here are three categories: residential, rural areas, and Monticello Historic District. Each one has that name in the zoning ordinance. Not mentioned here is neighborhood model district. So to try to stretch and say, well, the word residential also applies to neighborhood model district, which is what has been done in this interpretation, I think is inappropriate. Had they wanted neighborhood model district to be included here, they would have named it just like they named the Monticello Historic District. Both are planned development districts. Why name one specifically and not name the other one when you meant that other one to also be included? I mean, if they wanted it to be planned development, then say planned development. So I think, as both Mr. Herrick and Mr. McCall have said, we're not here to decide whether the ordinance is right, whether it's fair. I mean, we obviously think that this interpretation creates an unfair result for the applicant. But regardless of that, what we're here to do is look at what it actually says. And it doesn't say that the neighborhood model is part of this, this zoning section that says that the setback has to be increased. The other thing that the zoning ordinance doesn't say anywhere in it is that neighborhood model district is in fact a residential district. There's nowhere that it says that. They couldn't point to it because it's not in there. And the only thing in the staff report related to that just says it's, they've determined that it's residential based on consistent and longstanding practice. I'm not sure exactly what that means, but we all know that just because something has happened a certain way in the past doesn't mean that it needs to continue that way, doesn't mean that it's right. I don't think the fact that in the past, maybe that's the way that things have been determined is at all controlling in this circumstance. And that's why we're here, to determine officially how this should be viewed. And the neighborhood model district, again, is not in any way labeled a residential district in the zoning ordinance. In fact, going to what was up there before with the actual sections that deal with the neighborhood model, it talks about it being mixed use, mixes of uses and use types. But one particular paragraph that stood out to me is it said the neighborhood model district is intended to provide for compact mixed use developments with an urban scale, massing, density, and an infrastructure configuration that integrates diversified uses within close proximity to each other within development areas identified in the comprehensive plan. That paragraph does not sound at all like a residential district to me in any way that it's described. Certainly doesn't use the word residential, but just what it's described isn't how you would envision a residential district. And of course, it also references the comprehensive plan. For what it's worth, the property in question here, the comprehensive plan designation for that property is office, R&D, flex, and light industrial. So there's nothing about this property, not the way that it's zoned, not the way that it's used, not the way that it's listed in the comprehensive plan. I mean, if you look at the real estate tax records, its name is homeless shelter, its use code is motel, its house type is motel, its primary land use is commercial, and its zoning is neighborhood model. So where is the connection to residential? I just don't see it. Finally, if we want to look at the code of development, I don't think we have to. For all the reasons I just said, I don't think we need to get there. But if you want to look at the code development, as they say, block 1 is non-residential completely. Block 2 is labeled as mixed use or residential. Single family, detached and attached are not allowed anywhere. The only types of residential use that are allowed would be sort of commercial style residential uses, assisted living facilities, transient lodging. but looking at it, I mean, if you want to look at it overall, I mean, the huge proportion of uses that are permitted in this code of development are non-residential uses, and there's a very limited scope of residential uses that are allowed. Again, I don't think that's where our focus should be in analyzing this. I don't think we get to the code of development. What we're supposed to be doing is looking at what the zoning ordinance says. And it doesn't say anything about neighborhood model being residential, and it doesn't include neighborhood model in the section that's relied upon here for increasing the setback. So, you know, for all of those reasons, I don't think there's any basis for determining that this setback needs to be increased here. I do think it creates an unfair result, not just for this property owner, but for that entire section, all that abuts this property from 29 all the way up to the property of the applicant. And you know, there's no basis for it, and it's clearly not creating any benefit. So I'm not sure why anybody should want to stick with that determination. But we are obviously respectfully asking that you find that there is no basis for that determination and reverse the interpretation of the zoning administrator and allow the setbacks to remain as they have been without that increase. Happy to answer any questions.
Thank you, Mr. Karamis. I'm gonna open up for questions now.
Do you know what the setback would be? Just from commercial to commercial?
Whatever it was before, I'm not sure. Sue, do you know what the setback was before they included it? Or
It's a building code separation at that point, as far as the structure has to be separated properly per the building code, which I believe is like 10 feet.
10 feet?
Yeah, that's gonna depend on the style of construction type, right? So in the zoning ordinance, the setback would be 0. Whether or not the building can be there will also be subject to building code. So what they call the penetration, the windows, things like that, and the sides of the buildings would have to be rated, what they call rated assemblies, or no windows. Depend on the type of material, whether it's made of wood or concrete, that kind of thing would determine how close it could be to the property line at that point.
Thank you.
I'd like to ask a question on Westfield. Are there any other non-conforming uses similar to what you're applying for that exist right now that may have been given in the C1?
So structures, I mean, I think if you pull up that map, Francis, if you don't mind, the overhead, it shows you what's in that area now, and all along, you know, all of those properties that abut it right now do have structures within, and even maybe the one before that, Francis.
So it would be this lot, 450, this one, and then the front one, but that's, again, there's no other. So it's 1, 2, 3, 4, 5 lots that front along that property here. That's an MD property.
But there are a number of buildings there, seeing the 442, 450, 490. There's like that other building. I mean, there are some buildings already that would be non-conforming
Okay,
within the area.
So going back, if any of these buildings needed to be replaced because they were rotting out under the current NMD, they would not be able to replace that, correct? Unless they came before the body and asked what you're asking.
Right. And we, you know, we acknowledge what was said earlier, that there are other things that could be done here. I mean, we could do the special exception thing, we do the rezoning thing, but why should we have to when this isn't right? You know, the main thing here is whether or not this determination is right. It's not whether we have alternatives. So there might be alternatives to ask for a special exception, to ask for rezoning. Of course, both those things are discretionary. It doesn't mean we get it. Also means it takes a bunch of time and money to do. So if this isn't the right determination, there's no reason that we should have to go through those processes in order to get what we really should have from the beginning. Yeah, of course, please.
Susan Steinmart, applicant. So I'd add to Mr. Burkhart's question. There are oil storage containers at 450, which are not related to the building. So that's technically non-conforming, and I don't know if they could put it back. And then the Comcast folks who are in the adjacent parcel have equipment that they periodically store there as part of their operations, bundles of wire and things like that. So technically, I guess that's not a building. But it's just also to keep in mind that none of those buildings have the ability to expand under this condition. That was a concern for us, is we wanted to put in a storage shed for storing some of the oil filters. And we're not talking about anything very big, but that's where we realized the limitation of this circumstance is we didn't have any ability to build anything. Staff had advised us that we could put a storage shed, but it would have to be in the middle of the lot. So I don't know, Francis, if you wouldn't mind putting a mouse cursor right in the middle of the lot. And of course, that affects how we park vehicles, awaiting repairs or pickup. It adversely affects the circulation of vehicles. And there is another automotive repair adjacent to us who would have a similar problem. If they wanted to put in a storage shed, it would have to go in the middle of their lot, again, affecting parking circulation. It would effectively shut down their ability to park, presumably because it is a very narrow lot. Thank you.
Any other questions?
May I ask? Counsel, you make an interesting interpretive argument about specific and general provisions of the ordinance, and with three specific categories being listed in the ordinance, residential being one of them, and rural, I think, I don't remember.
Rural areas, residential,
Yeah.
and the Monticello Historic District.
Right, those three. So I would assume your argument is that anything that doesn't fit within those three specific categories is excluded from application. Is that what you're saying?
Yes, that's right. I mean, the section that's relied upon here by staff only, it says if the property abuts one of these districts.
Right.
So what I'm saying is it doesn't. I mean, it's not saying neighborhood model. So therefore the
Right.
property does not abut one of those districts.
Right.
Therefore, what follows is not applicable.
So hypothetically, if the ordinance did say that, heads 1, 2, 3, 4 being the NMD and abuts the NMD district, in your view, then these applications of the 50-foot setback would be permissible if it were written that way, which it is not.
That's correct.
That's your position?
Yes.
Okay. Which is, an interesting thing, the reason I asked my question about past interpretation of resident, the NMD being residential, having residential, is that it's kind of an unusual category. Use designations are specified in, R1, R2 have very specific use designations. And so, my feeling right now is, I wasn't persuaded at first by what you had said, but I'm kind of leaning your way. But let me ask a couple practical questions. Your property owner says, or you say, this is based on principle. And what principle is it that you're trying to vindicate? That's the first of the two remaining questions. Well, what is the principle you're trying to achieve by coming before us and asking us to overturn the staff interpretation?
Well, I mean, I would say the principle is you got to stick with the zoning ordinance. I mean, what the zoning ordinance says is what is permitted and what needs to
Okay.
happen. And if that isn't followed, then no one has any predictability or consistency in what's permitted.
Okay, so what I hear you saying is it's the precision of the drafting of the ordinance should not be expansively defined to include residential when it doesn't say that explicitly in the NMD definition. Is that?
That's
your
right.
point?
Yeah, I don't think
Uh,
NMD is a residential district.
Okay. I understand what you're saying. I'm coming to my final question. Should the board agree with you, and I have no idea whether it would or wouldn't, but should it, what are the limits on what you could do with your parcel? Just commercial C1 limitations?
Well, the only impact that your decision will have here today is whether or not we're subject to the 50-foot setback or not. It will
Just on
not,
that issue.
it will not change any use characteristics of what's permitted on any of the parcels. I mean, really, the impact here is whether or not
Okay,
if the NMD parcel is considered residential, then our parcel is subject to a greater setback.
Correct.
That is the problem. So if you all determine that NMD is not residential and then therefore this increased setback does not apply, then we're essentially back to where we were before. And the parcel
Okay,
is exactly
C1.
as it was before, with the
Right.
setback it had before and with the potential uses that it had before.
okay. Well, the reason for my question was not that, one second, I'll be happy. Yeah. You're saying the only issue here is the application of the 50-foot setback. So if we were to agree with you, what else could this is C1 property, I assume. So what else could happen on this property, on this site? Is it your position that if we agreed with you, that you could do anything that a C1 property owner would do or could do? Are there any NMD limitations on you that would continue? We're only talking about
Right.
setback here.
Right, well, the NMD is for the neighboring parcel. So that, the fact that that property is NMD does not change anything that can be done on this parcel, except for the application of this,
Yeah,
the
well,
setback.
Let me be more specific. You're trying to get us to decide that the NMD is not a residential property
Mhm.
category. I understand your argument. And if that were our conclusion, then I wonder if there are other limitations that the NMD category would apply, not just, if it's not residential, then is it just is your property C1 and you can do anything a C1 under the C1 rules, of course? Is that what you're saying? See, I'm trying to figure out if this is really only about a storage shed.
Oh, okay, so certainly the setback affects what can be done in that setback area. So
Correct.
whether it's a storage shed, which is how it came up, because that's as Ms. Steinmart said, that was what they were trying to do and what they wanted to do, and that's how this issue arose. Of course, because that was the plan, then, that is one example. But it really limits that entire corridor that you see in red, from any permitted use on the property of any of those properties.
Okay.
So
Well, I'm not concerned about the other properties. I'm concerned about your property. Let me be more specific. Is it your position that if we were to agree with you and not apply this residential connection, that you'd be able to expand your existing structure on this property?
I would say, subject to any other approvals that would naturally be
Right,
required, but from the county to do so, then
Right.
yes, of course, it would make
Okay.
that extra space
Okay.
usable
Okay.
that would not otherwise be usable.
Yeah, I've used too much time. I'll leave my colleagues here
I'm also happy
opportunity.
to elaborate, Susan.
Sure.
Steinmart. Yeah, so one thing is really important to keep in mind, and you may even see it from the graphic above, there is a 10-foot buffer. And that is the area from the property line into the 50-foot setback. So Francis was kind enough to denote that in this graphic you see
Back
here.
there, I see.
So that is in play regardless of what happens with the 50-foot setback. The buffer cannot be disturbed,
I see.
period, end of story. The other thing that's interesting to note for your own perspective, Mr. Rosenberg, is that there is a certain topography here
Mhm.
that you're not going to see from these graphics. The building on Westfield Road is approximately 10 feet, 15 feet below the property level of the adjacent homeless shelter.
below the property line, really, because you brought me out there to see this very same thing. There's sort of like a hill in between the two properties. That's a natural dividing line and a buffer.
I mentioned this only to say there's an important reason for that buffer. It's in the county code, it's not to be disturbed. And it would be a lot economically to go in there and dig out all of that dirt. Also, so practically speaking, the redevelopment of this parcel would respect the 10-foot buffer.
If it were just a C1
That's correct.
parcel.
That's
Okay.
correct. Thank you.
That's more specifically what I was asking.
Just curious, what are the dimensions of the shed that's being proposed?
It's, I'd have to defer to my husband on that, but the things that we do are store oil filters and some equipment. So it's not much larger than a garden shed. I think he had brought in the application to place the shed on a concrete pad that is existing. And it's just outside the parking asphalt. And that's what essentially was denied. So that was like 10 by 10, 12 by 12, something like that. 10 feet by 12 feet. Not very big.
I have to say that over the weekend, I did a drive-by on the street, as I try to do with every case that comes before, so I can get orientation on that. I would find it very, just in terms of what would happen, do you plan to expand? You're right, the topography is, there's quite a slope there. It'd be a tremendous expense. I think you can reasonably accommodate a small shed. It's not going to be huge, right? I mean, it's not big. I was just curious, did anybody else drive by the property, take a look at it?
It's just the challenge of putting the shed in the middle of the parking lot that creates the traffic flow issue I spoke of earlier. That's the issue. Sorry.
And I appreciate all those questions, but I don't think those types of things are the relevant decision-making points here. The issue is whether or not an MD is residential and whether or not there should be an increased setback. And regardless of what they want to do with the property, how big the shed is, or how, those types of things, those are all obviously practical issues that are going to be very important. But as far as reasons for the decisions that you all make, I'm sure the county would agree that those are not the types of things that are necessarily relevant to that decision.
Okay, quickly before we open up the public hearing, I think Mr. Swoboda would.
Yeah, I have
make
I
comment.
guess, a correction on the setback as we talk about this and we think about this line of thinking. If the NMD can't be declared residential, then it also can't be declared commercial. So I am not sure what that setback would be. It appears it would be 20 feet in the ordinance because it's from the district line, which would be what that property is zoned if NMD is different. So I want to make sure that that setback is clear on that. So I will tell you that we have not made a determination like this and how that applies. That's one of the reasons for when we look at like a PUD or a PDMC, right? Those aren't listed in this particular section as like the Monticello district and that Mr. Karamanis was referring to earlier. So I want to say that I don't know what the zoning setback would be. We would have to look at that, but it appears by ordinance that it would be 20 feet if this would not be residential. So just want to be clear. Again, I'm not making a determination from the microphone, right? I just want to be clear that I am uncertain at this point based on how we would do it past practice versus what we might do based on the decision here.
That be from the property line or from the buffer line?
We would have to evaluate that time of.
Yeah, the way
when they
it
would do
reads
something.
in the ordinance is from the district boundary.
So that would be the property line.
I would have to determine if the district boundary line is the property line. If it is the property line, then that would be correct. If it is not, I don't know. So without knowing how this property got rezoned, I can't tell you where the boundary line is. I want to make sure that our district maps are correct before I would make that call.
Thank you, Mr. Karamanis.
Thank you.
Well, I'd like to move into our public hearing portion of our meeting. And this is when anybody from the public can come speak to us and take up to 3 minutes. Members of the board are reminded that we're not supposed to discuss things in between members of the public, should there be any. All right. I'd like there are no members of the public that would like to speak. And so I would invite Mr. Herrick or Mr. McCall to take 5 minutes to respond, please.
No, I'm keeping it on top of the existing one.
Scroll to the top of that section, please. There you go. Perfect. All right. So let me pick up where Mr. Karamanis had left off. I am in complete agreement with Mr. Karamanis that issues like topography, the size of the structure and that sort of thing, while perhaps interesting, are not really what's before the board today. I will pick up, though, with some of the other comments that Mr. Karamanis had made about, for example, the neighborhood model district being a type of plan district. The way that the zoning ordinance is structured, there are a variety of different district listings. Monticello Historic District is one, Rural Area Zoning District is another. There are a variety of different residential districts. There are a variety of different industrial, commercial districts and so forth. But it's important to note that the neighborhood model district, despite being 20A, is not a subsection of the general planned unit development district that is section 20. So there's a section 20 that is a planned use development, but 20A is not a subsection. Those are different districts. And I would also note that the Monticello Historic District, which is section 11, is not a planned district. And I would also note, looking specifically at the language in question, I've asked Mr. McCall to call it up. And so we're looking at section 420, and you can see that there's a table that follows the following shall apply within the C1, CO, and HC districts. So that would be C1 commercial, commercial office, and highway commercial, which the Challenger Way property is. So then we go down to the side and rear minimum, because the side and rear minimum is what we're looking at in this case. And you can see in the side and rear minimum block of the table that there are two alternatives. There are two paragraphs, two subparagraphs within the side and rear minimum. The first alternative is if the abutting lot is zoned residential, rural areas, or Monticello Historic District. And you'll note that the only one of those that's capitalized is Monticello Historic. So residential and rural areas are both lowercase. So that's more of a general sense. That's not the residential zoning district. It's not the rural area zoning district. It's residential districts in general, rural area districts in general. I'll stop there and go down to the next part of that cell. If the abutting lot is zoned commercial or industrial, again, small c, small I, both of those are general commercial districts, general industrial districts. They're not identifying specific zoning districts. But those are the only two alternatives. Those are the mutually exclusive alternatives that the zoning administrator faces. Is it zoned residential, rural areas, or Monticello Historic District on the one hand, or is it zoned commercial or industrial on the other hand? Those are the only two alternatives that were before the zoning administrator in deciding which of those two alternatives to apply. And when faced with the facts and the past practice, this property was more appropriately judged to be residential. And that's the basis of the determination. So again, I'm happy to answer any follow-up questions that you might have. Yes, sir, Mr. Shepherd.
Top of my head, but I'm looking at that chart. Isn't a third alternative? None.
No setbacks?
Yeah.
No, I don't think so.
Says it.
Down
Well,
here,
that's for side and rear maximum.
maximum.
Oh, sorry,
Maximum, yeah.
jumped the gun.
Mr. Eric, I just want to see if you'll clarify something for me. Yes, sir.
Go inside rear.
But the side and rear on the bottom also.
Side and
says
rear
none.
none.
Yeah.
That is a third alternative.
It's it's side and rear maximum. So in these blocks, they have minimums
Minimum
And-
maximum.
and maximum.
What does the last line mean?
Yeah,
Side
what
and
does that
rear
mean?
none?
None, yeah, what is that?
That is for step backs.
Step back.
So there, it's an unfortunate indentation or non-indent or, separation here. But that, everything down, these two are have to apply to
So
step
there's no,
backs.
I see, there's no colon. No wonder it's confusing.
Okay. Mr. Herrick, I have a question. Reading over 4.20A, which you posted here. Now, maybe you weren't responsible for this, but why is it written if the abutting lot is zoned residential, small r, rural areas, small r, or the capital M, HD? Why do you think it was written like that as opposed to some mention of mixed use that includes residential? To be responsive to the council's comment about exclusive categories here. How would you respond to that?
Well, I certainly, I mean, if I were drafting the ordinance, knowing what we know now, it certainly would make both the zoning administrator and the board's job easier if mixed use were specifically mentioned, or if it were defined with capital words for the
Right.
proper names of the zoning districts. But unfortunately, in the absence of such specificity, we have to go on what we have.
Okay, so you would interpret those words residential and rural areas as being ambiguous terms not specifically linked to R1, R2.
I wouldn't use the word ambiguous. I'd use the word common as opposed to proper.
Okay, let me see if I understand. Common, COMMO?
In the sense of the use of common nouns versus proper nouns. Those are common
I
words.
see, okay. So a more general, but you say zoned residential. See, that's where I'm getting caught. And maybe that's just an impossible problem. And that's the reason, a council in the back, that I asked the question of prior consistent interpretations. And first of all, I view this as being, from the county's argument, an ambiguous interpretation. It could be specifically tied to residential categories. It could not, it could be, as the county argues it, more general to mixed use, as what seems to be your argument. And then implications of the effect are not irrelevant to interpretation of ambiguity, counsel. And administrative law teaches us that prior consistent interpretations by an administrative body are relevant to interpreting the quality of their consistent interpretation and reliance that flows from that. And that's why I asked the question of prior cases. So, I understand your attempt to categorize this, but I don't believe what I was trying to show was irrelevant. And I will give my time to others.
Mr. Herrick, you said that Monticello Historic Districts are not planned development districts. Sorry, the Monticello Historic District is not planned development district. And I came to this meeting thinking that that was not true and that there were 7 distinct planned development districts. And that in 8.1, section 8.1, Monticello Historic District is listed as the first one. Is that, where am I missing there?
All right, so I stand corrected. You are correct that section 8.1 does include that listing, which includes both of them. I was looking at the structure of it, and it's not, my point is it's not a subset of the planned unit district. Right.
Understood. Thank
No.
you. I
No,
just wanted to make sure.
but I appreciate the correction. You are correct that section 8.1 does list them together, and so I stand corrected.
Wasn't trying to correct you. I just wanted to make sure I was clear. But thank you. All right, any further questions for Mr. Herrick? All right, we would
thank
like
you.
to give the floor to the appellant for 5 minutes
Yes.
for any responses.
I think I have much more to say, but I appreciated that. The one thing I wanted to say was to point out section 8.1, which you just did for me. That does show, lists the planned development districts. That's what I was relying on when I made that comment initially. Obviously included among them are the Monticello Historic District, which was specifically mentioned, and the neighborhood model district. Whether or not the words residential and rural areas are capitalized, I honestly don't find all that important because you have to read the ordinance as a whole. And having done that, I still don't see any place that says neighborhood model district is residential. So that's the bottom line. That's what we were, relying upon. These are the types of things, the reason that this types of decisions are important is that, when that property was applied for rezoning, and you as a neighbor, you see that the property next to you is being rezoned and it's being rezoned neighborhood model, and you think, okay, fine, I don't have any problem with that. I don't have any problem with what they're trying to do over there. But if you have no idea that the end result of what they're going to do is to take away 50 feet of your property, that's a problem. And so, the clarity here is very important, not just for this matter, in my opinion, but just in general for people to understand this distinction and honestly, if a rezoning like that is going to affect the setback on a neighboring property, I feel like that needs to be part of the notice that goes out to that neighbor to let them know that that's a potential impact. That's a different story, but it is related to this determination. And so, that's why I think that this is, it's very important. And I don't think that it is fair. And I know we're not just determining things on fairness here, but Mr. Rosenberg said, the impacts are important. It's only fair for everybody to know what the ordinance says and that what it says is what's going to be done. And, if that's not what was intended, then obviously there are processes for that. I mean, the Board of Supervisors can go back and rewrite this. If they don't like the determination here and they want it to be a different way, then the ordinance can certainly be cleared up to make it however they want it to be. But based on what it says today, we don't believe that this is the right interpretation, and we would ask that you rule that same way. Thank you.
Thank you, Mr. Karamanis. Just open the floor for discussion.
I'll say something here. Just think I'm heading in the direction of finding that the determination was incorrect because the property, because 420 applies to the residential rural areas and Monticello district. It does not mention the NMD district. So just where like to me, the clear, plain meaning of those words completes like sort of the beginning, middle, and end of my thinking about this as far as my final decision goes. I also would just toss in there that a lot of the discussion about is residential versus commercial. I feel like there are a lot of commercial uses within the neighborhood model district. I think transient lodging is a commercial use. It's off to the side, but I want to say that. Thank you.
Thank you.
I agree with what John has said, but I also want a little aside to you. I don't know if I'm going to pronounce your name right, Mr. Karamanis? Close, okay. We do go down in the weeds because we do think it's really important for us to really understand what's going on. So when we look at the code of development and we look at the map that shows the blue, that shows residential, it occurs to us, yeah, that's what staff was looking at. But then when you look at the code of development, that probably cost Premier Circle a lot of money to have somebody create for them. I mean, it really does open up the possibility to have lots of commercial activity there along with the residential. So for that reason, and because I was around when the neighborhood model was created, it's supposed to be flexible. It's not supposed to create burdens for itself or for adjacent owners. So for that reason, I do appreciate the work staff has done, and I do understand that this is very confusing, the words in the ordinance, and what you were trying to do is make some sense of it. So I appreciate that, but I don't agree with the determination.
Thank you, Ms. Joseph.
I believe questions and ambiguity of the definition about the residential characteristics of the NMD, and as such, because this needs to be further clarified, which I don't believe it has in this determination provided to the applicant, gives me reason, or I should say I'm more inclined to support the applicant in this appeal.
Thank you, Mr. Burkhart.
I have no further comments. I intend to vote with Mr. Burkhart.
I would just offer a moment of commentary that, you know, I kind of did the high level take that Mr. Karamanis was suggesting, which I think is found in section 7.1, which establishes districts. And it establishes 26 total districts. 6 of them have the word residential in front of them. And then there's the rural areas. And there are others, 7 of which are defined planned development districts. And so I don't find that those planned development districts fall under the heading residential. I find that they need to be called out, just like the Monticello Historic District was, as a planned development district that the setbacks would apply to, the increased setbacks. And just to take it a level further, I think when we get down into the weeds, as my board members have said, which I don't have clarity on whether we should or not consider this specific code of development. I think that's a good question that we could all wrestle with for a long time. But this specific code of development allows for lots of by right uses that are outside of what I think all of us would define as residential. Mr. Bowling.
I'm hesitant to say something because I'm afraid I'll confuse the issue further, but I feel like that it would be important to point out a couple issues here. Regardless of how you vote, as the county attorney said, the issue of fairness is not before you. The posture of this case is you have an appeal of zoning official determination. And under the statute that you operate under, he's entitled to a presumption of correctness. That means that all things being equal, he wins. It doesn't mean he can't lose, but all things being equal, he wins. So you have to keep that in mind. And the other thing that's here too is that I think you do have to consider the code of development because it's part and parcel of what you're involved with. Your task is made more difficult because unfortunately there is no definition in the zoning ordinance of the NMD district. There's just a statement of intent. And it'd be nice if we had before us a nice little statement for everybody saying the NMD district is a residential district, but we don't. So we're left with what we're left with. And I'm going to stop there. I think I've said enough. Thank you. I hope I haven't meddled things further.
Sure. Yeah, I would suggest the same to the board members that in my opinion, it doesn't matter whether this is a small 5x5 shed or XYZ of the most intensive use in C1. And then I also found, just to put a cap on my statements, I found it interesting that the NMD district could not include any residential. It would take an active board of the Board of Supervisors assessing that there are, residential uses within a quarter mile that satisfy that. But if that was done, an NMD district could include just commercial and industrial, or just industrial and institutional, as long as it has two different types. So I am done with my comments and would ask for further discussion or any motions. You didn't type it up.
So Mr. Carrington, just as a clarification, it's three different motions you can do: affirm, modify, or overturn. I believe I've heard that you all are looking to overturn, so that's the one that I've put up at the top there on the screen.
Thank you, Mr. McCall.
I move that we overturn the zoning administrator's determination on LOD 2023-00010.
Second that.
Hearing a motion in a second. Ms. Alley, would you call the roll?
Ms. Joseph,
Aye.
Mr. Rosenberg,
Aye.
Mr. Shepherd,
Aye.
Mr. Burkhart,
Aye.
Mr. Carrington,
Aye. The determination is overturned by a vote of 5-0. And we can move into the next item on our agenda. That's the approval of our January 9, 2024 minutes. I'd like to open it up for any comments or edits, discussion.
I would like to add one thing under new business. Is just a point of clarification. I've been following the legislation. I understand that the bill is before Governor Youngkin. I believe he has until either April 8th or 11th on the revision or the amendments to the virtual meetings. Is that correct?
Yes, sir. That's my understanding as well. It's that bill has passed both houses of the General Assembly and is awaiting the governor's signature.
Thank you, Mr. Garrett. Hearing no comments on the minutes, are there any motions?
Move they be approved.
I'll second.
Hearing motion and second to approve the minutes as submitted. Ms. Alley, would you call the roll, please?
Mr. Rosenberg,
Aye.
Mr. Shepherd.
Aye.
Ms. Joseph,
Aye.
Mr. Burkhart.
Aye.
Mr. Carrington,
Aye. Minutes are approved from January 9th, 2024, a vote of 5-0. So we can move on to old business. We have one item on our agenda, which is the discussion of possible appointment of alternate BZA members. I think many of you will remember the history here, and I think that a draft letter was sent out yesterday for consideration. First of all, I know I asked Miss Alley to send it out, and I have my name at the bottom, but much of the legwork, all of the legwork was done by Mr. Burkhart and Miss Joseph. So thank you for that legwork, guys. You're welcome. And I would open the floor for discussion about that draft.
I thought it was good. Or to put it another way, I think our discussion has been good on this, I think, and that particularly, I think it was vastly improved by Mr. Rosenberg, who asked us to put this in a larger context, to look into it further. And I think that the letter reflects the benefits of it that we sort of took, that I think that many of us sort of just assumed were good from the get-go in terms of, covering absences, serving to as an incubator for future members, that sort of thing. But also it reflects looking into what other localities are doing, their experiences. I mean, we know that that's behind the request. And I think it tees it up for the Board of Supervisors in a way that they can have a good discussion about it. That's why I say, I thought it was good.
Yeah, Mr. Carrington, I was initially not enthusiastic about it, but I was persuaded about the utility of it. And today's case is a good example. If we had three people here, had a quorum, and then three of us would have to make a decision, a complicated decision. And I think it's important that we have as many of the five or people to make these questions, ask these questions, make these comments that we heard today in deciding cases. And as I said, when we discussed it, I think earlier, I think that's what the person who comes before us expects, kind of a full amplified discussion of their case, because they've gone a long way. They're challenging what the staff has said. And so I think if this, I'm not wild about spending more county money, but keeping it to one person, I think, is a wise limit on it, probably necessary. And it allows the applicant to be fairly confident that there won't be three, there will be at least four, if not five people here when Mr. Carrington is on his vacation or the rest of us. And so I think I would support this letter going to the Board of Supervisors. And, if someone wants to make it more persuasive and more forceful, that's fine with me too.
Like to add one small point
Sure.
to your remarks, and that is a 2-to-1 finding is bad, but a 2-to-2 finding, I think, is worse. I mean, the possibility of a tie is a very unsatisfactory conclusion to one of these matters. So I would just add that to the
Hopefully,
lack of the quorum.
yeah. Well, hopefully this
Excuse me.
alternate will make sure that there'll be an odd number and not an even number, so we won't have that problem too.
Yeah, just quickly on that point, I see Mr. Bowling over there squirming in his seat, wanting to tell us that if an applicant does get a tie or foresee a tie, I know they do have we now know as a board that they have the right to ask for a deferral.
It's not the board, it's the applicant has the right to
Applicant
ask for a
does,
deferral.
Not us.
And then when I wrote you, Mr. Chairman, I forgot to point out the most important effect of that. That means not only does the staff have to do a redo and the board have to do a redo, but the public that appeared at the hearing has to come back again.
Right. So even if deferral is requested and granted, it tees everybody up to have to do it over again.
Have a
Yeah, right.
do-over.
Understood. Thank you.
Another reason.
Joseph, after doing all that legwork, Mr. Burkhardt, anything?
It took us a long time, didn't it, Kurt? It did take us a long time, but we finally got through it. And I just wanted to say something about the letter, is that I sent a draft to Mr. Carrington and it came back changed. And I was so thrilled, because oftentimes when you send somebody something, they don't read it. They just say they're going to sign it. So I was thrilled that he read it, he edited it. So this is, I mean, he's signing it, so he better believe in what he's signing. So this, I think, was a really good exercise. And Kurt did most of the work and really talking to other boards I just got a couple. He misunderstood and did some that I was supposed to do. So I was very happy with that, but but anyway, it was interesting to talk to people because they really did feel as if they benefited as a result of this. The guy from Green, you know him. I mean, what he talked about is that they had a turnover quite often. And so it was really good to have somebody to be able to just step right in. Well, the other thing is I don't know if you read through, but some boards are salaried. Yeah.
Salary.
Some are salaried.
Oh,
so
really?
We couldn't get. But I thought, but anyways, I expect that those localities have a lot of projects, and issues coming before them. So, and you also need to know Charlottesville, they don't pay those people. So don't spread that around either. But anyway, it was interesting and, I enjoyed working with Kurt also. So thank you.
Let me just say, it was great working with Marsh on this project. Fairfax County was the last one that I contacted. You probably know Leslie Johnson up there, was having they had a whole new zoning ordinance that they previously had passed, and then it was held unconstitutional, and then they had to go back and so they were presenting that, I think, last week. But the big challenge for them is that the longevity on the BZA is such that you've got some members that have been on literally for decades. And then you've got people that, have termed out. They've got some more that are terming out up here. And it's like any other kind of volunteer organization. They're just trying to get applicants to apply and vet them out and get people seated. So it came at a time while they had vacancies on their existing board, where they were just trying to get, the idea of a alternate coming in because of the same reason we have. But they also meet weekly, and unlike ours, they also deal with special use permits too.
Thank you. I would just arc back to what Mr. Shepherd said about Mr. Rosenberg's early comments. I think your skepticism produced a better request. So I appreciate that. And I'm grateful for all of this board's discussion and certainly the legwork by Ms. Joseph and Mr. Burkhart. And I think it would be appropriate for a motion to authorize me to sign this letter and send it on our behalf.
Mr. Carrington, before you make that decision, just want to point out that address it to Jim Andrews, not Anderson.
Oh,
I didn't catch that and I apologize, and we will correct that. So
Yeah.
with that edit,
That's some serious editing.
are there any motions to send the letter with that correction? Thank you very much. I don't know that our request could go very far.
Andrews, not Anderson. Okay. Mia culpa. Anyway, I move that with the edit to Andrews, that we approve the letter to the Board of Supervisors requesting an alternate member to the BZA.
Hearing
Second,
a motion in a second, Miss Ally, would you call the roll?
Shepherd?
Aye.
Mr. Burkhart?
Aye.
Mr. Carrington?
Aye.
Ms. Joseph?
Aye.
Mr. Rosenberg?
aye.
All right, motion passes 5-0. And I will work with Sally and any other staff members that we need to work with to get that letter out. And certainly we'll keep you fellow board members apprised of the status. We can move on to new business. And we have no items on our agenda. Does anybody have anything?
No?
Okay, I'll just quickly add that we can, as a board, be prepared for next meeting to discuss the representation agreement with Mr. Bowling. And I think that Miss Ally will tee us up to have a closed session for that discussion, but in the past, at least couple years. That agreement has been on an hourly basis of $350 per hour, with a cap of $5,000. And I know there's been some tension, on hitting that cap recently. So there's some context for y'all to be thinking about in the meantime.
And I'll tell you that the work ebbs and flows, and it's largely dependent on how many public hearings you have and how many people participate and how big the packages are you get. And in some years, I have been well under the cap, the $5,000 cap. For the last 2 years, I think a year and a half, year before I was right at it. And then last year I was about 4 hours over it. So it left less money on the table. One thing that causes me concern is that at the end of February, there was a major sea change in zoning law in Virginia, which I'll be sending you some information on. Mr. Shepherd will be happy to know that his opinions and view of what happened in 2015 for the variance law were correct.
Right.
At least for the Court of Appeals side of things.
Pastor, but I don't remember.
Well,
This was
take it.
the Moss case and gentleman who constructed an office within the setbacks. But in any event, the Court of Appeals determined that the amendments to the variance law that took place in 2015 indeed were a substantial change from the previous law, and that are, at least I think, and maybe Mr. Herrick will pipe in, is going to need a lot more work certainly for the zoning staff and also for the BZA potentially once legal counsel in the area learn about this case.
Yeah. Mr. Bowling, I read that case today, as a matter of fact, and I had the 2015 statutory amendments, I think were very property owner oriented in terms
Yes.
of changing the rule structure. And maybe we'll see a lot more cases because of if lawyers are aware of the changes. But I read that opinion, and there's it was a pretty well done opinion. They're not always done that well.
Well, I won't comment on the
Yeah,
merits of the opinion, but I will say it's going to, at least I think it's going to result in substantially more
Yes.
staff time
Yes.
and ultimately BZA time because of the fact orientation of
Right.
that opinion.
Okay, give us a synopsis, because
I'm not going to do
No,
that.
it's too
That's a waste of
complicated.
time.
Well, then
with all due
send us
respect.
the stuff.
What,
Mr. Bowling's going to
That's
send it
what
out
you're
for us.
talking
No,
about.
but you do know what the variance statute
Right.
says, and basically it's really been focused on, is there a substantial hardship?
Hardship.
And
Okay.
now they've changed that to the second prong, and they put an emphasis on the
Reasonable.
reasonableness of the facts that are at issue. And the way they wrote the opinion,
Okay.
it seemed to be if you spent enough money on what you needed to do to get around the hardship, you were okay. That's being the cynical view, but that's one way of reading the opinion. But I'll send out a copy of the opinion, but it's certainly a different way of looking at the law than that was present before this opinion came down. Now, the Court of Appeals, any decision of the Court of Appeals is subject to appeal to the Supreme Court of Virginia, but the rub is that takes a long time. And it may not be appealed too. This was a case that came out of Louisa, I think.
Well, thank you. And I'll just add, first of all, thank you, Mr. Bowling, for all your years of service, and we certainly look forward to trying to extend that. The way that agreement is written is it is subject to the Board of Supervisors allocating those funds. So we can plan to handle that at our next meeting.
Didn't we approve something earlier because we were trying to do that on an earlier basis so that it would get into their budget? And their budget is what, approved in April?
I think the goal was to have it on the agenda today, and I probably didn't move as fast as I needed to move in order to make that happen.
I just keep thinking, go ahead.
So we're in the budget cycle.
Okay.
The amount that we have set now is currently in the proposed budget. So
Okay.
any changes,
Okay.
it's not that we didn't carry it forward. So we know as staff that the Board of Zoning Appeals was interested in retaining Mr. Bowling. So the current contract funding is in place and is requested in the budget. The board hasn't approved it yet. So that's where we are. I don't anticipate that coming out, but at this point, it's still under review. We had a budget meeting actually yesterday.
Okay.
Thank you.
And I've lost track of what the cycle was. Periodically, the clerk, Marcia, you want a letter from me. And when's the last time we did that?
I believe the last time was in January. Hang on just a second.
So at least this gets it, the issue before you all even,
Yeah.
it doesn't matter with the current budget is the current budget, so be it. But it gets it before it gets your attention.
Yes, sir.
We had discussed the last time when you all made the agreement and signed the agreement to try to get that discussion to take place earlier in the year. So we tried to put it on we didn't try to put it on there. My intention was to put it on the January agenda for the election of officers and just an organizational meeting and get that covered in that somehow. It was an oversight on my part, I believe. It did not get added to new business. So we knew we were having this meeting. We wanted to try to get it at least addressed here to see how you wanted to handle it. If it was something that you wanted to go ahead and just move forward on, we were prepared to go ahead and have that ready today if it was a brief discussion. But if you wanted to have a more open closed session, an open closed session discussion, there was not a room available for closed session today. So I will get that organized and reserved for you for the next scheduled meeting, if that's okay with you.
Thank you. Yes, let's plan on that, please.
That way it'll give you a closed session room to have your discussions, to come up with what your terms are going to be, and then you can come back and.
Thank you. Are there any motions for adjournment?
I'll make the motion that we adjourn the March 12th, 2024 meeting of the Board of Zoning Appeals.
Can we ask,
Hold on
is
that.
there an item for next month?
Sorry.
That's where I was going. So based on what we have schedule wise, right? So we're talking about time frame with this, is that we're not anticipating another item until June.
Okay.
So is June a time when you want to talk about it, or would you want to do it sooner?
Good question. I don't understand the process very well in terms of,
Well, what he's saying is that June, it's already too late, isn't it? I mean, to get the budget increased. That's really what he's saying in a nice way. So.
and is there an avenue to have additional funds allocated after that budget is set?
Yeah, there's a process for the board to do out of budget allocations.
But you want
it's
to
a big
avoid that
deal.
like the plague. That's staff's.
Kinda, yeah. And so I didn't know if you if you wanted to address this sooner or later. So I just thought I'd put that out as an option.
What I can do is send out the case and just tee it up and I don't mind, I'll copy Andy too, to show you how the case, because it is going to, once this case becomes well known in the legal community, there it should lead to a substantial increase in your variances and your workload.
Yeah.
How long that'll take, who knows? So I
Okay.
can do mostly that. I can do that all by communication with the board, if that's what you want me to do, Mr. Chairman.
So are you saying maybe we have an April meeting where we actually talk about this case and look at at your proposal?
Well, I don't think that's what I'm hearing, because it's already, what the zoning administrator says is it's too late, the boat has sailed. That the budget is set in stone, and the only way to get around it is to have a special issue for the Board of Supervisors, which generally is frowned from the staff side of things on the zoning, on budget process.
Okay.
Yeah, we would, once we find out what's going on and review the case a little bit, probably after the review takes place here, or what we anticipate. And after the discussion about Mr. Bowling's contract, we would inform the board through the proper channels that, hey, we're going to anticipate probably some more action during this year and potentially years forward based on this case. So
Right, because
Okay.
I'm just a small cog in this process. The staff also is going to be affected.
So Mr. Svoboda, is today too late? If there was a motion or a desire on the board to act right now, change that request without going into closed session, because it doesn't sound like that's available.
But could we go into closed section right now?
Sure.
And that would just mean we read the thing about, pursuant to such and such a code, we're gonna go into closed session to discuss Mr. Boland's pay. All in favor, we go into closed session and then we come back out and say, talked about what we said we were going to,
Adequate notice.
and do it right here and right now.
yeah,
You can do that, but you have to have the magic language that you need not to go in, but you need to have the right code site. But you need
Have
to
the
have
code
the
site.
magic language after you come back out, maybe.
Would
if
you
we
like to
could-
do that, Jim? I mean, it's like,
Well, I think it doesn't matter because from what I'm hearing from the zoning administrator is the boat's already sailed on
Okay, so the
on
next-
budget
all right,
process.
then I won't
But-
try to.
Yeah, it
Push
may
it ahead.
tee it up for.
yeah. Long story short, for all the departments within the county, we were asked to toe the line. And
Yeah.
that was
so
part
it
of the
would just- it would
discussion
be, it would-
yesterday.
it
Thank
would-
you.
It would just be out of sync with everything. So it's
Sure.
hate to say it from my economic perspective, it's hopeless.
Well, Mr. Bowling, thank you, and we will try and be respectful of
But
your
I at
time.
least but it is an issue it's worth raising, just for what's gonna happen, unless I'm sadly mistaken.
Yeah, I think we'll look at our process also and maybe when we do our final meeting of the year, also put that on there as a reminder to make sure that we don't extend that first meeting too far beyond either January or February, but make sure it gets on that agenda. So we'll try and put some double checks in there to make sure that happens.
Great, thank you. I think we may be ready now for a motion to adjourn.
I I didn't withdraw the motion. The motion still stands. You're waiting for a second.
I second that emotion.
Hearing a motion in a second, Ms. Alley, would you call the roll?
Ms. Joseph,
Aye.
Mr. Rosenberg.
Yeah.
Mr. Shepherd,
Yes.
Mr. Burkhart.
Yes.
Mr. Carrington.
Aye. Motion to adjourn passes 5-0. We are adjourned at 3:48. Thank you so much.
Got a run, kid.
Listen, you're going to get together because I have to.
Oh, okay,
Well, but good for.
Yeah, for me. but
great.
not good
Thank
for-
you.
Thank you.
And you look fabulous, by the way.
Thank you.